UK Supreme Court rules transgender women are not legally women under Equality Act. In a landmark ruling that has sent shockwaves through the ongoing gender rights debate, the United Kingdom Supreme Court has ruled that transgender women, even those who possess gender recognition certificates, GRCs, do not fall under the legal definition of woman as defined in the Equality Act. 2010. The case, widely seen as a flashpoint in the increasingly polarized conversation surrounding gender identity, was brought forward by the Gender Critical Campaign Group for Women Scotland, FWS. Supported in part by famed author J.K. Rowling and advocacy group Sex Matters, FWS made the case that the term woman in the Equality Act must be interpreted based on biological sex, not by self-identification or the acquisition of legal documents such as a GRC. The Scottish Government, which aligned itself with trans rights advocates, defended its policy position. Its legal team leaned heavily on the Gender Recognition Act of 2004, which asserts that anyone who has been issued a gender recognition certificate has legally changed their sex for all purposes. According to the Scottish Government, this change should extend to legal protections under the Equality Act. However, the UK Supreme Court did not agree. The panel of 5 justices ruled that defining woman to include transgender women introduces severe practical problems. In their written judgment, the court stated, the meaning of the terms sex, man, and woman in the Equality Act 2010 refers to biological sex. Any interpretation to the contrary would render the Equality Act incoherent and unworkable. One of the central concerns raised was that extending the legal definition of woman to include trans women could undermine the specific protections designed for biological female such as those related to pregnancy, maternity. The court also found that classifying trans women with GRCs as having a female certificated sex creates additional complications. Deputy President of the Court, Lord Hodge, said this interpretation cuts across the definitions of man and woman in the Equality Act 2010, and therefore undermines the protected characteristic of sex in an incoherent manner. The ruling emphasized that treating sex as a matter of certification rather than biology would also weaken protections for those with the protected characteristic of sexual orientation. For example, it could interfere with the rights of lesbian-only associations to maintain exclusive spaces. Further, the judgment highlighted the potential for widespread confusion and impracticability in areas such as the operation of single-sex charities and associations, women's access and fair participation in sports, the implementation of the public sector equality duty, regulations in settings like the armed forces. In response to the ruling, the UK government welcomed the decision, emphasising the importance of biological definitions when it comes to safeguarding single-sex spaces. A government spokesperson said, "We have always supported the protection of single-sex spaces based on biological sex. This ruling brings clarity and assurance for women and for service providers like hospitals, refuges, and sports clubs. Single-sex spaces are protected under the law and will continue to be safeguarded by this government," the statement concluded.